There are specific infirmities that were enumerated by the plaintiffs in their complaint that we have consented to. And how do I know we haven't addressed any of them? The plaintiffs allege that we should never have crossed Tampa Bay from Pinellas County. We've done so in 2 of these maps. How do I, as a legislator, vote for a map, whether I like it, overall, when I know it specifically flies in the face and ignores one of the primary or fundamental objections that were raised by the plaintiffs that led us to this point here today?
If I may start. President Lee, what we did when we entered into the consent was not to agree with the allegations set forth in the plaintiff's complaint, specifically with regard to Tier 2 characteristics. The consent was limited to a Tier 1 mission and then went on to, in fact, say, not identify a party, not identify an incumbent, and not identify a district. And the purpose of doing it that way was so that we were not admitting the veracity or the merit of any individual Tier 2 characteristic, but recognizing, based on the standard of review that had come from the Florida Supreme Court, that the likelihood that we would be found to violate Tier 1 was going to be an issue. And so because of that, the way to cure that infirmity was to reestablish a process, a sterile process, if you will. But I don't think that once we've got past that sterile process or into that sterile process, it then is incumbent upon us to go back and make sure that we're checking off any or all of the allegations in the complaint. If it was approached correctly and the Tier 2 requirements were followed just as Tier 1, I think as a committee and as a legislature, we can analyze those maps and consider them compliant.
So, Mr. Chair, then it would be your representation that simply fixing the process and readopting the same map would result in a cure.
That's a arguable position.
Well, I think that's a ludicrous position.
Well, it is. If you had,
I wouldn't make that argument.
Well, and we didn't. We ultimately adopted a process to start anew, start at the beginning. But at the heart of where the issue was, and that the catalyst for the consent was in fact the Tier 1 allegations.
Well, Mr. Chair, I just think people need to read this amended complaint, because I don't think that's what it says at all. I think it's very specific as to maybe why we did what we did, but what we did is the basis for why we're here. And if we don't fix these things as we go about trying to address the map, and we just ignore the court's direction to us as a result of this consent, this thing's going to get kicked out again. And I just hope whatever we do, we hold up to the light against the infirmities that have been alleged by the plaintiffs that we have admitted. And we can say, well, we didn't specifically admit to them, but there's also a legal theory out there that I'm aware of, talking to lawyers, that because we didn't specifically say that any of these infirmities do not apply to the map, that we've admitted every single one of them. And so I would just suggest to you, maybe when we get into the Senate meeting, we could have a little bit more dialogue on that, because that's definitely in dispute.
Okay, you want to comment, Justice Montero?
Thank you, Mr. Chair. We specifically did not agree to the specific districts that were alleged as unconstitutional. We agreed in general that the map was unconstitutional, but we didn't say District X, Y, or Z was unconstitutional. And many of the arguments that they made as to the unconstitutionality...
Mr. Chair, look, in all fairness, if you're going to sit here and tell us that you had a right to object to these allegations and you did not, but therefore we didn't admit to them either, I mean, which is it?
We answered the complaint and we denied the allegations.
We considered that the map was unconstitutional, and we in no place did we object to any of the allegations made by the plaintiffs. No place did we say that any of these allegations are inaccurate. Why didn't we do that if we objected?
Chair. We did object. We answered the complaint. We denied those allegations. And the consent judgment did not contain an admission of those specific allegations.
I have a voluminous number of complaints that have been made by plaintiffs, and we have not denied any one of them in this consent judgment.
Ms. Quintero?
Thank you. What we stipulated to in the consent judgment is that the enacted plan violates the provisions of Article 3, Section 21 of the Florida Constitution. We did not admit specifically which districts were violated. So there was no admission as to any particular districts. There was admission as to the plan as a whole.
Mr. Chair, then could rational minds then just conclude that you could look at the glass half empty or half full, that we never admitted that all these districts were unconstitutional, but neither did we ever deny it?
No, we admit that the map as a whole was unconstitutional and that we agreed that we were going to redraw the map. We didn't say any specific district was drawn unconstitutionally. So the fact that we now go into Pinellas from Tampa Bay doesn't mean that we violate any of the stipulation or that we had agreed that we weren't going to go into Tampa Bay. Their allegations of why we went to Tampa Bay was because it was it violated Tier 1, not the minority protections, but that they argued that it was drawn with the intent to favor or disfavor a political party or an incumbent. So we come back here and we draw districts that go into Tampa Bay, and we state the specific reasons why we had to go into Tampa Bay. And if the map drawers said that they had various options that did not go into Tampa Bay and they did not perform for minorities, and the map drawers affirmed that they had no intent to favor or disfavor a party or incumbent, then I think that district will be approved. And the district that they're presenting in those maps, none of those maps go into Manatee County as the enacted plan went. So it is not the same configuration as the enacted plan's configuration. And in fact, it's similar to the NAACP's suggested configuration. So I would defend in court that map and that district because it was drawn without the intent to favor or disfavor a party or an incumbent, and because it meets the minority protection criteria, and because that's the only way to protect minorities in that area.
Mr. Chair?
Well, this doesn't have anything to do with minorities.
Yes, I'm talking about the,
I'm talking about I'm just using the example of allegation number 50, which says that we jumped from Pinellas County into South Tampa, and that we did that to favor a political party. And what you're saying is, well, if we just do it and it still favors a political party, then, but we didn't mean to do it, we can just reaffirm the old approach for a new reason, and the court's going to find that's okay.
well, if the map drawers came to an independent conclusion without having looked at what was done before and decided to draw a district a certain way, then I would defend that because they were coming in independently of what had been done before, and they weren't doing it with any intent. And of course, the way you draw a map is going to have political effects, and the Supreme Court accepted that. But if you don't have the intent and what the political effects are, doesn't make it unconstitutional.
Could you elaborate on a little bit why?
Well, I don't want to belabor the point, but if you go through and you read this consent order, the plaintiffs, we have the burden of proof. Stakeholders, the plaintiffs are going to be entitled to file plans, and we're going to have a lot to prove. And so I think we need to go through here and address the infirmities, and just simply sending them back a map that happens to look like the old map but was drawn without intent, I think is not going to fly.
It's some general unhappiness about not the consent that the Senate agreed to as opposed to fighting this. So that decision, I know it's gone back a while now, but you seem to have some dissatisfaction.
No. I think I understand. I think as a layperson what the awkward situation the Senate was in. The courts had already ruled on the congressional map using the evidence that was mostly related to the Senate map. It was pretty clear you know, where this was headed, and to cut our losses and to get into a remedial process and restart redrawing maps rather than continue to spend hundreds of thousands of dollars in court seemed to make a lot of
So you didn't have a
sense.
problem with that, but I guess you thought maybe they should have at least had the map drawers in the room. They should have had some of those complaints.
I do.
Okay.
You can't
I
have
just
it.
wanna make sure I
Yeah, you
understood.
can't have it both ways. You can't agree that, you know, your map's unconstitutional and then submit one that looks just like it and say, yeah, but we didn't do it with intent. It's going to get thrown out, and it should.